This episode concerns key issues which arise for entrepreneurs following the enactment of the new Polish whistleblowing law. These matters will be explained by Dr. Jakub Znamierowski, advocate and senior associate in Wardyński & Partners criminal law practice. Jakub advises clients on compliance, conducts internal investigations and represents clients in criminal matters. Later, we'll hear an update on the Polish economy.
Nearly 2 years late, and as one of the last in the EU, Poland has finally introduced domestic regulations concerning the protection of whistleblowers. The relevant law, the Whistleblower Protection Act of 14 June 2024, enters into force on 25 September 2024 and raises numerous issues on how companies operating in Poland should comply with it. In this film, I am going to address the most critical aspects. I selected 5 of them which relate to 3 areas of concern: introduction or adjustment of relevant whistleblowing solutions, conducting proceedings relating to whistleblowers' reports, and counteracting risks connected with abuse of whistleblowers' rights. Let's have a look at these in turn. The Polish Act requires companies that employ in principle at least 50 persons to adopt internal whistleblowing policies. Obviously, numerous issues are involved, but there are some that frequently recur. The first concerns old policies. We often hear, okay, we've had such a policy in place for a long time. Maybe it doesn't specifically use the word whistleblower or whistleblowing, but it still intends to investigate unlawful actions reported to our company. Isn't that enough? Well, that depends on whether the old policy meets the statutory criteria specified in the Whistleblower Protection Act. If it does, we would say that you do not need to change its wording. But there is still one important thing to remember. The Act requires the whistleblowing policy to be consulted with trade unions. Therefore, if that has not been done previously, it must be done now. The second issue relates to establishing joint whistleblowing policies for a group of companies and allowing whistleblowing reports to be received and follow-up actions, especially internal inquiries, to be taken by one team appointed by the group. Is this permissible under the Polish Act? The general principle is that private entities which employ 50 to 249 persons may establish common rules on accepting and verifying whistleblowers' reports and conducting internal inquiries. I believe that is quite clear. More controversially, regarding corporate groups, the Polish Act provides that private entities that are part of a corporate group may establish a joint whistleblowing procedure. However, the Act does not expressly mention receiving reports and taking follow-up actions at group level. There are currently 2 positions regarding their permissibility. Briefly, one view permits reports to be received and follow-up actions to be taken by one specialized unit in the entire corporate group. This is supported by the argument that as corporate groups are allowed to adopt joint whistleblowing procedures, and as one of the essential elements of such procedures is appointing an internal unit or person who receives whistleblowers' reports and takes follow-up actions, corporate groups are allowed to have such shared unit or person for all the companies within the group. Forbidding this would make adopting joint group whistleblowing procedures impossible and the legal provision itself inapplicable. The second position says that adopting a solution which allows follow-up actions to be taken by one unit in the entire corporate group is inadmissible and that such actions should be taken separately by each entity in the group. This interpretation is supported by the argument that the Polish Act does not refer to such solution in corporate groups and that it does not transpire from the EU Whistleblowing Directive. This is also because the follow-up actions are to be taken by an internal unit or person, whereas such units or persons are internal to just one of the companies, but external to the others. At present, we cannot be entirely sure which interpretation will prevail. Until this is resolved, it may be prudent to appoint the same person responsible for follow-up actions at each entity in the group. The case is, however, a bit different for international corporate groups with Polish entities on board. As these fall under different jurisdictions and the Polish Act principally refers to domestic entities, the Polish companies in the group will need to adopt their own policies and conduct their own internal inquiries. International whistleblowing systems may be an additional option, but should not substitute for solutions at Polish entities. The next area of interest relates to responding to whistleblowers' reports. Here, the third question arrives. Are Polish entities obliged to accept anonymous reports? In this case, the answer is more simple, with some exceptions relating to so-called obliged institutions, such as banks, which are required to accept anonymous reports relating to money laundering and terrorist financing. Anonymous reports may be, but do not have to be, accepted. The fourth question is how to address reports made in bad faith. Well, there's no single answer to this, as the way you should deal with such reports will much depend on the circumstances of the matter and the time when you actually learned that the report was indeed made in bad faith. In general, a whistleblower is protected under the Polish Act from the time of the report, provided that he/she had reasonable grounds to believe that the report contains true information on a violation of law. If the report concerns deliberately untrue information, there is no protection. In any event, the entity should verify if the information in the report is true and be allowed to investigate it, especially if it suspects that it may have been deliberately manipulated. The most intricate issues that will probably arise with the new whistleblowing law will concern strategies of defense against instrumental whistleblowing. Our final question in this film: how to defend oneself against such actions? I believe there are multiple contributing factors. One will certainly be to build an appropriate whistleblowing culture, which should serve as a mechanism destined for the common good of employees and the entity. The second will be a careful examination of reports, enabling separating out those involving true suspected violations of law from those made in bad faith. The third should involve working out a considered and appropriate way of responding legally to malicious reports that contravene the aims of whistleblowing. The issues discussed in this film are some of many which we have come across in relation to the new Polish Whistleblower Protection Act. The Act is to be reviewed after 2 years, and we can expect it to be amended. The future will tell how employees make use of the new whistleblowing instruments. However, it appears that the Act heralds the end of a certain era when internal inquiries into violations of law were rather sporadic and limited usually to large, often international, entities. Dealing with reports may be challenging, but they may yet be treated as an early warning mechanism, which eventually, at least in some cases, may help prevent bigger problems.
For the time being, the risks posed by the ongoing war deter investment in Ukraine on a larger scale, and there are no big contracts for infrastructure reconstruction. But the Polish government has already set up an insurance system for exports and investments, and Polish business organizations are developing a network of contacts with Ukrainian entrepreneurs so that Polish companies can quickly become involved in the reconstruction of Ukraine in the future. Already, 1/3 of all EU exports to Ukraine are Polish exports. From 2024, southeastern Poland is a hub for Western military aid to Ukraine, and in the future it could become a bridgehead for Western companies to rebuild Ukraine, as the overland route to Ukraine via Poland is the fastest and most convenient. However, even the end of hostilities in Ukraine will not trigger the rebuilding of the country, nor the large-scale involvement of Polish business in it, if Ukrainians do not combat the corruption, especially at a high level, that the country has faced since independence in 1991. Thanks for watching this episode. See you next time.